Mr. Herrera, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. This case is 143 days. You mind reading what happened, please?
Yes.
So you were given a general order bond. Looks like you took on, it looks like we did probable cause, I'm assuming. I found probable cause at the time. We ordered you not to drive, and then I guess went AWOL. You've now made a surety bond. So yeah, do you mind reminding me what happened, please?
On November 5th, 2025, a traffic stop was conducted on the defendant's motor vehicle after it was observed that he had expired registration. Upon contact with the defendant, the officer observed watery, bloodshot eyes and the odor of an alcoholic beverage. The defendant admitted
He's driving. Oh, I mean, this is this case,
expired.
because he just picked up a felony, I see.
Yes, it was a PC.
So I guess, yeah, go forward with this one, and then I want to know what happened in the felony. Please.
Absolutely. The defendant admitted to drinking a can of an empty Budweiser that was found on the passenger floorboard. SFSTs were conducted. It was a 2 out of 6 on the HGN, a 6 out of 8 on the walk and turn, and a 1 out of 4 on the one leg stand. The DIC was read and the defendant consented to breath, but provided unacceptable samples. The defendant then consented to blood, and a blood draw was conducted. And we do have the results of that blood.
You do or do not?
We do.
Okay.
And it came back for a 0.05 of ethanol, as well as methamphetamine and amphetamine and THC.
Okay, what happened in the felony?
Yes, Your Honor.
Please.
There we go. On March 22nd, 2025, the officer observed a vehicle displaying a fictitious buyer's tag, and a traffic stop was initiated. The defendant, the driver, provided a Texas driver's license and warrant checks. Provided a Texas driver's license, and the warrant check revealed an outstanding warrant, which led to his arrest, and that would be the DWI. During the inventory search of the defendant's property at Pasadena jail, officers found a clear zip bag containing a white crystal-like substance identified as methamphetamine, which weighed 0.87 grams.
I'm sending you now for a drug test. I want to know what, if anything, is in your system as of right now. If you fail to go test, if you fail to come back, I'm going to revoke your bond and make it so high you will have hair falling out. Do you understand, Mr. Hara? And the next time you miss court, likewise, your bond will reach the clouds. Do you understand? Sir, take your seat for me. Good morning, Mr. Juarez. Sir, you're charged with criminal mischief. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 22nd, 2025, officers were dispatched at around 2 a.m. to a burglary in progress call at 2717 Stony Brook Drive, apartment number 411 in Harris County, Texas. The officer observed the defendant to be sticking his head through a broken apartment window from the outside of the apartment. The complainant stated that the defendant began banging on her door and window, trying to get inside. The complainant stated that she had no idea who the defendant is and she had never seen him before. The defendant then broke the apartment window with his right fist and appeared to be trying to get inside the apartment. The complainant stated that she was scared for her and her children, who were also inside the apartment.
And it's a mischief?
The complainant stated that the damage was $100. The officer observed the window to be broken, and the defendant had cuts and blood on his right hand for breaking the window, and there was also blood on the
You're not charged with a series of felonies. Mr. Juarez, I'm going to find that there's sufficient probable cause to go forward with your case, and I'm now going to put an ankle monitor on you so I know where you are at all times, and I'm giving you a curfew. If I find that you're a danger to my community, I only have one place for you. Do you understand? You are not to consume alcohol or illegal drugs. I'm sending you now for a drug test. I want to know what, if anything, is in your system. If you fail to go test, if you fail to come back, I will revoke your bond. Do you understand? You're not to be in possession of any weapons. You're not to go anywhere near where these people live, work at all.
The court's information, there should be it looks like they're complaining all these cases live on the same street that this mischief happened on.
Any connection, you think?
The defendant did state on the scene that he believed that he was at a different apartment on Dunleavy and wanted his mom to let him inside. Explains anything, Your Honor.
Regardless, I'm going to send it for a test now. I want to see what, if anything, was in his system.
Here, I was just more for population.
Guys, on everything, waive the fees for everything, please. I'm going to send you for a test now. Come back. Do you understand? If you don't test, if you don't come back, it's not going to go well for you. Take a seat for me. You literally pled guilty, not 10 days ago, and now you're back again. You now stand charged with the offense of fleeing a police officer. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 20th, 2025, officers were conducting an active patrol at the 15,300 block of Corona Del Mar Drive in Harris County, Texas, and observed a black GMC Sierra traveling at a high rate of speed in a residential neighborhood. The motor vehicle attempted to slow down once they noticed the marked patrol vehicle by hitting the brakes. At that point, the officer observed a defective taillight. The officer quickly
0.05 BAC might be under the legal threshold, but once you factor in meth, amphetamines, and THC, the situation escalates fast. At that point, it's no longer a simple alcohol case, it's polysubstance impairment. Should combining drugs automatically trigger tougher consequences than alcohol alone? An ankle monitor paired
10 to 20 miles per hour. A defendant disregarded 2 stop signs and then parked his motor vehicle in front of his residence and opened the motor vehicle door. The defendant was then detained. He stated that he was coming home when asked why he did not stop and was identified by his passport.
So no license?
There is no driver's license on file.
Mr. Melendez, you're not allowed to drive. If you do not have a Texas driver license and you don't have liability insurance, you're not allowed to drive. You will be signing an affidavit with me today promising you're not going to drive. I don't care what you need to do in life. If you don't have either, both, and permission from us, do not drive. Do you understand?
Yes, sir.
Since the 10 days, you put your arms down. Since the last 10 days that you were here, what have you done to change your life? What better have you done?
So, I'm on my own in school. Right now, I'm doing a job, Chick-fil-A.
That is now a condition. You must do one of either, in school or a job. I'm going to appoint your lawyer today, and I'm going to bring you back in 2 weeks to see what you have done. If you've done nothing, it's not going to go well. You understand? All right. I'll have you sign a reset. I'm going to have you take a seat in the jury box. So you're on bond for an interference and a failure to ID from November. A month later, you pick up a criminal trespass, and now you pick up a 4th case, another criminal trespass. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 17th, 2025, an officer was made aware by Voyager Apartment Complex, courtesy officer that the defendant was trespassing on the property. The officer stated that he observed the defendant and due to previous encounters knew the defendant to have a criminal trespass warning from the property. The defendant was detained. The defendant has had numerous criminal trespass warnings from the location and a recent arrest for criminal trespass due to being on the location. He was identified with his Texas driver's license.
Was this the same trespass as the prior one?
Same location, Your Honor.
Same location?
Your Honor, am I able to speak for that?
No. What I'm going to do is I'm going to put an ankle monitor on you so I know where you are at all times. You're not to consume alcohol or illegal drugs, and I'm also giving you a curfew. If I find that you're out in the middle of the night, if I find that you go anywhere near this, I'm going to take all your bonds now, and I will triple, quadruple. Do you understand? I'm going to protect my city at all costs. You not have 4 open cases. You have made bond on those cases. If they gave you a PR bond, that I'm telling you now, you pick up a 5th case, I'm going to make your bond so high you'll have teeth falling. Do you understand?
That's all.
Tell me about the interference, please.
Yes, Judge. So on November 26, 2024, an officer heard a verbal disturbance in a parking lot while patrolling on foot in an apartment complex. The officer made contact with the defendant and a female. The officer attempted to identify the defendant, who refused to identify himself and stated, "I'm not identifying myself." The officer is.
Same complex.
Let me check.
Yes, sir.
Stop.
Yes, Your Honor. Same complex.
I don't want you to go within 1,000 feet of this apartment complex. Do you understand?
Yes, sir.
I have a monitor that I'm going to put on your ankle today. If it dings anywhere near there, I don't care what your excuse is. It's not going to go well for you. Your cases are now from November of 24. It is way too much drama for me. So you will get a lawyer today, and in 30 days, is discovery complete on the cases from 24? It's way too much drama. I'm ready to set these off for trial.
Discovery is complete on the interference, Your Honor. And
Very
discovery
good.
is also complete for the previous criminal trespass.
Get ready. I'm fast tracking this trial, 30 days.
Yep.
So I'm gonna appoint him a lawyer today. I'm gonna have him take a seat in the jury box, have him meet with the lawyer. 30 days it gets set for trial. You're not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, likewise, it won't go well for you. You understand? All right, come on. Good morning, Mr. Nguyen. You speak English.
Yeah.
Mr. Nguyen, you're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 21st, 2025, an officer was traveling southbound on Grand Way. The officer was driving 80 miles per hour in a 75 mile per hour zone. He then witnessed the defendant operating a motor vehicle pass him and pass him from the improved shoulder. The officer followed the defendant and witnessed the defendant change lanes when unsafe, drive on the shoulder, follow other vehicles too closely, drive without lights when required, and pass on a no passing zone, disregarding the safety of others.
Okay. Mr. Nguyen, I'm going to find that there's sufficient probable cause to go forward with your case. Can you run his license, please? Do you have a license? As a condition of your bond, I'm ordering you not to drive like this anymore. If I find that you do, I will revoke your bond, put you in jail. Do you understand?
His driver's license is eligible.
You're not allowed to drive unless you have valid liability insurance as well as a Texas driver license. Do you have the ability to hire a lawyer, Mr. Nguyen? How old are you?
18.
Okay. We'll provide you a lawyer today. You will be signing bond conditions. I'm telling you now, jail sucks. At 18, if you end up going to jail, they will have a field day with you. Do you understand?
With a strict curfew is essentially confinement without a cell. Is that a reasonable middle ground? Or should repeat offenders skip the alternatives and go straight to jail? And let's talk about ignition interlock devices, the built-in breath test that won't let your car start unless you blow clean. Do measures like this actually reduce impaired driving in your area, or do people always find ways around the system?
Good morning, sir. So you're charged with the offense of falsifying drug test results. You are facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 22nd, 2025, an officer, while assigned to the Harris County Toll Road Authority DWI Task Force, observed a vehicle traveling 87 miles per hour in a 65 mile per hour zone. The officer observed a traffic stop was initiated and the officer observed the strong odor of marijuana. And the defendant stated he personally smoked marijuana earlier that day. The defendant offered to allow the officer to search his vehicle for marijuana. The officer conducted a probable cause search of the vehicle and located a firearm. The officer also found a liquor flask-sized opaque plastic bottle in the glove box with a temperature sensing strip on the top containing a yellow liquid. The defendant stated he purchased the bottle so that he would not fail a drug test to get a job.
Any open cases?
No open cases, Your Honor.
All right, Mr. Onikidi, I'm going to find that there's sufficient probable cause to go forward with the case. Sir, do you have the ability to hire a lawyer?
I actually have a lawyer. I'm surprised it's not him.
You do have a lawyer. Let me see if any documents have been filed. Do you guys see anything? Are they going to, who,
What'd you say?
are they, you've hired them?
Yeah, I did hire them a couple of days ago.
But they
said they'll
told
show
you they
you.
would be here?
That's going to.
Who is it?
He's from Gilligan. I don't really.
Say Gilligan?
Yeah.
I guess let's do this. I'm not going to put any conditions on your bond. Well, hold on a second. Does he have a license?
He does. It is eligible, Your Honor.
You're not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. Do you understand? That is a condition of your bond. I guess I'll have you sign a reset now. We'll have you take a seat. It's still kind of early. We'll wait to see if they come. Do you have a phone number?
Yeah,
Maybe you
can
can
I
go
call
call them and see if they'll come, and then we can address your, but don't leave until we excuse you, okay? All right, please.
Judge, that state's bond condition?
Yeah. You are Victor Ortiz.
Yes, Your Honor.
Mr. Ortiz, you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed.
On March 20th, 2025, an officer observed a vehicle traveling with its rear license plate lamp out, making the license plate unreadable. A traffic stop was initiated. The officer made contact with the defendant, the driver, and the officer observed the strong odor of an alcoholic beverage, watery bloodshot eyes, slurred speech, stumbling, and the defendant used the car for support. During an inventory search of the motor vehicle, the officer located 4 open containers, 2 empty and brown bags cold to the touch, 1 half empty, and 1 freshly open. All 4 were cold to the touch and they were 4 logos. The defendant denied drinking the alcoholic beverages and admitted to being an alcoholic, having a drinking problem, but he stated that he did not have any idea how many alcoholic beverages got into the motor vehicle. SFSTs were refused. The defendant was read the DIC and declined to provide a specimen. The defendant was arrested and a blood warrant was signed and executed.
Mr. Ortiz, I'm going to find that there's sufficient probable cause to go forward with the case. I am now taking away your privilege to drive. You are not allowed to drive. I don't care what's going on in your life, and you are signing an affidavit with me today, promising me you're not going to drive. If I find that you do, I can have a contempt hearing, and every time you drive, it's an offense punishable by up to 6 months in jail and a $500 fine. Do you understand?
Yes, Your Honor.
You will now get a portable device that you're going to take with you everywhere you go to prove to me that you're not consuming alcohol. If you fail to blow into the device, if you consume alcohol, if you consume illegal drugs, I will revoke your bond, put you in jail. No more PR bonds. Do you understand?
Yes, Your Honor.
If you have a problem with drugs or alcohol, you better address it. Now is the time for you to address it, because if you don't, and it becomes a problem, I will address it for you, and I promise you're not going to like the way that I do it. Do you understand?
Yes, Your Honor.
I am now also placing a restriction on your license that you're not allowed to drive any vehicle that doesn't have an ignition interlock on it. We send this notice to DPS so that everybody in the entire world, or I'm sorry, all officers in Texas know that if you're driving, you must have an interlock, and if you don't, they will put you in jail.
Yes, Your Honor.
No alcohol, drugs, random testing, and the portable device. You have the ability to hire a lawyer, Mr. Ortiz.
No, Your Honor.
I can have you fill out an application. I'll take a look to see whether you qualify. I need to know everything about you. How much money you have at the bank, what you do for a living, what kind of car you drive. and then I'll take a look to see whether you qualify. Deputy Miranda is going to give you an application. I'll have you sign a reset with Victoria. You'll get with pre-trial for your bond conditions, and after that, we'll take a look to see whether you qualify. Mr. Smith, you're charged with 2 cases. You're charged with possession of marijuana. You're also charged with unlawful carrying of a weapon. On the gun case, you're facing up to a year in jail and or a $4,000 fine. On the weed case, you're facing up to 6 months in jail and a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 23rd, 2025, an officer had conducted a traffic stop for expired registration at 567 South Mason Road in Harris County, Texas. The co-defendant was taken into custody for 5 active warrants. The driver was asked to take a bag with him containing his personal items. Inside the bag, the officer contained a small white plastic bag containing multicolored chocolate pills known to be ecstasy and Xanax. The co-defendant claimed ownership of the pills. A probable cause search was conducted and officers located a handgun with ammunition located behind the driver's seat on the floor of the vehicle, a baby bottle containing promethazine cough syrup, and a clear cylindrical container of marijuana. The total weight of the ecstasy pills was 8.4 grams. The weight of the Xanax pills was 118.2 grams. The weight of the marijuana was 0.05 ounces. The weight of the promethazine cough syrup was 5.19 ounces. The defendant, the passenger in the vehicle, claimed to be the owner of the marijuana and the gun and stated that the gun fell out of his pocket and landed behind the driver's seat.
What about promethazine and all that? Who's was there a second gun?
No, there was just one firearm, Your Honor.
Did they charge the other gentleman?
Yes.
So how can they charge him with it then?
So he took ownership of the marijuana and the firearm, the defendant. Yes. The co-defendant took ownership of the ecstasy.
I thought you said that the co-defendant said the gun fell out of his pocket.
No, the defendant said that.
Oh, got it. Okay. All right. Mr. Smith, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to have any contact with the co-defendant in this case. Do you understand? I'm also ordering you, can you run his light? He's a driver, right?
No, he was the passenger, Your Honor.
Got it. All right. Oh my. I'm ordering you as a condition of your bond not to be in possession of weapons. Do you understand? Do you have the ability to hire a lawyer, sir?
No, sir.
I'll have you fill out an application. I'll take a look to see whether you qualify. I need to know everything about you. Are you working at this time?
Yes, sir.
Okay, I need to know everything about you and I'll take a look to see whether you qualify. Do not leave until you sign our bond conditions. All right. So no contact with the co-defendant and no weapons, please.
Yes, Your Honor.